the counter, new case, same day. Welcome to the verdict room, where we're seeking the truth, no spin. Bringing you the facts so raw, let the evidence speak again. Exposing all the secrets, looking for the lies in the cracks. They throw revelations at your feet till the gavel comes down on the facts. Hey! Typically unique, but the method is clean. Red string on the board, map out every scene. Replay the last call, rewind the last text. If it don't add up, they on to what's next. Side eyes, alibis, tear them apart. Trail through the dark with a flashlight heart. Bronx on the story, keeping pace on the track. Every minute, every motive, never holding it back. Welcome to the verdict room, where we're seeking the truth, no spin. Bringing you the facts so raw, let the evidence speak again. Exposing all the secrets, looking for the lies in the cracks. They throw revelations at your feet till the gavel comes down on the facts. Week after week, you know the sea's still warm. Cold case heat brewing up in the storm. From the Bronx to the booth, they connect every clue. When the hammer hits the wood, you know the verdict is you. Welcome to the verdict room, where we're seeking the truth, no spin. Bringing you the facts so raw, let the evidence speak again. Exposing all the secrets, looking for the lies in the cracks. They drop the gavel one last time and the truth keeps pulling you back. Yeah.
All right. Welcome back to the verdict room, guys. I think this is what, episode 5, 6, something like that. Welcome back. It is
Hello,
great to have
everybody.
you. Hello, Miss Kim, Mikey, and Miss Logan. How are you tonight?
We're great. How are you?
Wonderful. It's great to see you guys here again. Thank you for joining us. Appreciate you so much. And thank you to all of you beautiful people that are here joining us tonight as well. We have a great show tonight set up for you, and a very special guest joining us tonight. Mr. KEVIN Curtis is a Washington State defense attorney, going to be joining us as we break down this unbelievably crazy case that we've been talking about for years, on discussing the WSU lawsuit as well, going along with that. And it's nice at times to be able to have people that have the background that Mr. Curtis has to be able to discuss these things. We all have plenty of questions about this crazy stuff, and it's nice to have input from a professional that can actually give us some real answers to some of the questions. So,
and he's been right there close, Coeur Lane, and
Right, exactly, Mike. And for those of you that haven't, we found Mr. Curtis via Mr. Andrew Myers, who you all know is a very good friend of the channel, and he very, very happily said, I would love to see you guys get together with Kevin, so on and so forth. So here we are, and I'm very grateful to Andrew as well, and of course Mikey, the producer here, for putting this all together. He did an amazing job at a very short period of time. So awesome. So at that point, guys, I'm going to go ahead and bring Mr. Curtis up here, introduce him, and we will get moving. Welcome, Kevin. How are you today?
I'm doing well. Good afternoon.
It is absolutely wonderful again, sir, to meet you, and I'm grateful, as we all are, to have you here with us tonight. So thank you for being here.
My pleasure.
Absolutely. I just you follow any other channels and anything like that besides Andrew Myers at all on YouTube, or is this newer to you?
No, the only podcasts I've been involved in have been with Mr. Myers. I have been providing commentary to the local NBC affiliate in Spokane, Washington, which, as you folks may know, is only about 20 miles from the Idaho border.
Gotcha.
And only about an hour and a half, 2 hours from University of Idaho and Washington State University.
Okay. Awesome. If you don't mind, if you could give us a little bit of information on you and your background, where you're located and all that, if you're okay with that.
Oh, sure. I'm happy to do so. So I actually came up here from Los Angeles to go to law school in 1978. I graduated in 1981 from Gonzaga School of Law. I've never made it back to California. I started practicing at the public defender's office for about 13 years, 14 years until 1996. I then went into private practice with a local firm here called Winston and Cachet Lawyers. It's about 20 to 30 lawyers, depending on what era you're talking about. One of the few large firms that actually did criminal law. So that's been my specialty from the beginning. Handled a fair amount of high profile cases here in Eastern Washington. I've been president of the two criminal defense organizations. There's Washington Defender Association, which is primarily affiliated with public defender groups, and the private practice is with the Washington Association of Criminal Defense Lawyers. So I've served on the boards of both and been president of both organizations. I have moved, gave up my partnership a year or two ago. I'm now of counsel, so I can pick and choose if I want to get involved in a case or engagements such as these.
Amazing. Very interesting. Wonderful background, by the way. I'm grateful to have you here with all that. So, and you said you were located. I'm sorry, I didn't hear that part clearly. Where at again?
It's in Spokane, Washington,
Gotcha.
which
Okay.
most folk nationwide don't know, but they may have heard of Gonzaga University
Yes.
because primarily of their basketball team.
Yeah.
So that's where Spokane, Washington is located.
Right. Gotcha.
We're so we're in Eastern Washington, almost on the Idaho border.
Okay. Got you. Okay. Amazing. Again, welcome everybody in chat. Again, thank you to the moderators for being here and everybody else. We appreciate you so very much for joining us tonight. It's great to see you all. Obviously, again, Kevin, you're is it okay if I call you Kevin, or would you prefer Mr. Curtis? Which I just want to be as respectful.
I much prefer Kevin.
Okay. Good stuff. So you're obviously familiar with the Idaho 4 University of Idaho murder case, the quadruple homicide, unfortunately, I'm sure.
Yes.
And everything that's going on with that. And I guess we'll probably start there and move forward from that point. Does anybody else here have anything you wanted to go ask him before we go forward with any of that before we do?
I do actually. Hi, Kevin. Good to meet you. My name is Logan. So you're a criminal defense attorney, and with that, what is some of the cases that you've worked as far as the penalty? I don't think Washington has a death penalty, but have you worked cases where there were life sentences involved?
Yes, Washington did have the death penalty.
Oh, they did.
When I was practicing for up until, I think first the governor may have put a stay on it sometime in the 2000s, and I think it was abolished statutorily or sometime in the 2014 or 15. But regardless, we don't have it anymore. I've worked on 5 death penalty cases. Only one of them went to trial here in Spokane. It was a 6.5, 8-week trial. As in most death penalty cases now, states require that you have 2 death qualified attorneys working on the case. I worked with an attorney named Dutch Wetzel, just a tremendous lawyer. And while we worked together on most of the case, I handled primarily the guilt phase, and Dutch was responsible for the mitigation phase. Dutch got the benefit of the bargain on this one because on the guilt phase, the jury hung 6-6 on guilt. So we never got to the penalty phase.
Wow.
The other 4 cases were resolved. I believe one of them was resolved to a plea down from aggravated, which is required to have a death penalty enhancement. So that was reduced down to a first-degree premeditated. Basically means the person was eligible for parole or probation after 20 years. Yeah. The other 3 cases were resolved with pleas. with the state removing the death penalty and the client agreeing to a sentence of life without the possibility of parole.
Oh, wow. So, just one more question because it's more of a general question than specifically having to do with Idaho. When you start
Sure.
working a case at the very beginning, and let's say it's a homicide case, are there set steps that you take, like, just generic kind of steps that you need to take in the beginning before you get into the nitty-gritty of the case?
Well, I think each attorney who handles serious felonies probably has their own method for constructing them. There's always going to be similarities, but I think to this case in particular, in a death penalty case, there is much more of a checklist, basically standard operating procedure that you're going to follow from the very beginning. The mantra that defense attorneys use, and I mean it's true, to both educate the court and the prosecutors, some of which have not had death penalty cases, is that death is different. When the state's seeking the death penalty, there's a lot of different things that happen even from a serious homicide case. And so that includes, if you want to ask why a checklist, the first thing you're going to do is you're going to get to your client and you're going to the best of your ability, shut everything down until you can start getting your arms around the case. You're going to try to get to know your client, but the most important thing is to convey to the client that there absolutely cannot be any communication with him to anybody about the case. Obviously the press, but the family, to visitor, anything. So you need to really shut down anything from the defendant side. And then you immediately know that you're going to need a mitigation expert for the guilt phase, and there's certifications for that type of position. And that's because you're going to tear apart that person's life from birth or perhaps even pre-birth if there were prenatal issues, to see if anything down the person's life, their childhood, their school, their activities, experiences, injuries, etc., that may down the line be important if you have to be in front of the jury attempting to mitigate death as the punishment. So you're going to need, obviously, a mitigation expert. You're going to need at least one investigator, if not more. You don't know at that time what type of forensic experts you're going to need, but you have a pretty good idea from the news media. In this case, that you're going to be needing a DNA expert. You're going to be needing a blood spatter forensic. You're going to be needing a weapons, as obviously there was the report from the beginning that the knife, there was a knife that appeared to be the deadly weapon. You probably know that you're going to need somebody on cell phones and, the search, pinging cell phones, being able to track numbers exactly. So that you're going to be needing those things. So you're getting those in the back of your mind lined up. You're meeting with your client and then attempting to explain to them the process and what a roller coaster it's going to be over the next probably 2.5 to 4 years. I mean, the average death penalty case takes around 3.5 years to get to trial.
Wow.
Yeah, very nice.
Very interesting. Very, very much so. And I didn't even think about this in the beginning. A little bit of background real quick on all of us. I am a retired firefighter, EMS first responder. Logan works in the medical background and has. Miss Kim over here to the right is a retired teacher, educator. Mikey down here is a business owner, entrepreneur, and digital whiz, I guess I could call at some point, because he's helped us really get to this point with a lot of this. So that's what we all have done and do, if I'm correct on that, everybody. Is that right?
Yep.
Okay. Just wanted to make
Yes,
sure
sir.
I was right. Okay. So just to give you a little heads into that, and we all just decided that one day, we didn't like the way some things were going in the world, so on and so forth. We wanted to talk on it, discuss it, figure it out, and have all come into the aspect of investigative reporting, independent reporting, whatever you want to call it at that aspect. And this case specifically, brought us all to the surface for air because it doesn't make any sense. It really doesn't to a lot of us. Hence, one of the reasons why you're here with us tonight.
Well, I understand, and I think the investigative reporting is, in this day and age, becoming, really critical.
Yes.
From a democracy standpoint, and so I applaud all of you for this endeavor.
Thank you. Thank you.
It's nice to hear you say that. Thank you.
Now, what is your take on typically back in, let's just say, we're going to say the old days, investigative reporters actually worked for news agencies. And the real investigative reporters seem to have fallen off, but yet people that are doing some of that real type of work that should be done are criticized. I don't know. What's your opinion on the real investigative reporters kind of disappearing from media, possibly?
From what we used to consider, first it was only the media. When I was growing up, you had CBS, ABC, NBC, and PBS to some extent as well, which was doing some spectacular, just straight news. And you believed, at least then, you were watching straight news. Obviously, over the years, it's been politicized, and now as very wealthy people absorb news medias, you can look up many sites on the internet to see where these various media companies, where their bias may or may not lie in terms of from the extreme right all the way to the extreme left. And it's very confusing to people. It's very convenient for politicians, who want to spin and be using the media as a mouthpiece. So it's very, in my mind, from growing up as a younger person watching Walter Cronkite, and the mainstream, to see what now is happening and how information is being disseminated, for political purposes rather than for news purposes. And more germane to your question, right now, investigative reporting, I read the LA Times. I mean, they would do spectacular investigative reporting and subscribe to the New York Times. And, from a cost standpoint, we've seen what's happened to, newspapers, and people want sound bites, and people are looking at times much more for affirmation than for information. And, there's still a large segment of the population, aging as it is, that doesn't trust, the web, podcasting, and investigative reporting coming from that. So it's a confusing time for a lot of people, and you have to be very careful, I think, about when you receive information to verify it and check up on it before you start passing it along to other people.
In any of the cases that you've been involved in, could you say that maybe there was even one that you were just fighting and you were like, oh my God, this is getting very difficult because of the media getting involved?
Right.
Yes. When I started and started doing higher profile cases, still generally your standard response was no comment at this time. You generally would have some relationships with the reporters from the local area. You could talk a little off the record with them. But as information became more instantaneous, in other words, a story about your case, they might call you up and say, I'm doing a story that's running in a day or two about this, and then there would be a newspaper article, and that would be it until you got closer to trial.
Yeah.
That has changed, and my approach to dealing with the media on high-profile cases changed, where that they're probably going to be running a story, and there's going to be follow-up and comments, and people are going to be viewing it as soon as it's posted, because most of the time media stories are even posted before they're aired on the 5, 6, or 11 o'clock news. So you need to be communicating or putting something out, some sort of comment, some sort of soundbite, something to respond and attempt in some way to get whatever message you're attempting to get out to the public. And a no comment generally isn't a very, very good comment to do. So depending on the type of case, etc., the messages can be very different, but you do want to at least get some portion of your story out there so as to not to, damage the potential jury pool.
But kind of in essence, with the real investigative reporters being gone, that will then in turn make an attorney such as yourself very timid to exactly what you just said, not wanting to speak because you don't know really who you're speaking with and how they're going to twist it and turn it. In my opinion, that's what I'm just kind of
Agreed.
taking.
Well, yeah, you have to be really, really, really careful. Without showing any bias. I mean, we've seen, I think, in many administrations nationally, but particularly in this current one, that inexperienced people are having extensive conversations with reporters and not understanding what background or off the record or any of those things mean. And they're just talking away and I think doing damage to their ultimate client by doing it.
Loose lips and ships.
Yeah. And I prefer to kind of do those communications through a press release that I disseminate to all of the organizations, in the area. And then they can kind of quote from that or put that in versus trying to do a lot of live sound bites. So that's what I try to do when I know something is coming out. I try to be responding to it in that way. So it's out there for everybody to see. They can pick or choose, and it's a little picture of me on the release I send so they can say, Kevin Curtis said, and then they can block quote, the portions of the release that they want to use.
Of course, yes. Great question, Mike. Very good question. Kim, Logan, anybody before I say anything else?
I do. If Kim, do you have one? I have one more for him. You're muted, Kim.
Thank you. I was just wondering, just generally, are you surprised at the interest and public criticism, conflict about this Idaho murders case from the attorney perspective?
I can't say I'm surprised. I mean, it obviously happened in a relatively rural state, Idaho, and we're on the West Coast, not the East Coast, but the nature of the crime, 4 college students, the manner in which it was committed, wherever this happened, it was going to be a national story, and that the national media was going to be flocking to it. So I can't say I was surprised by the interest in it. It's just one of those cases that's going to be on the national table until it's resolution, and in this case, much past the resolution of the criminal matter.
It's definitely, and it's gone in a worldwide level at that point. We have people that watch from South Africa, Thailand, Norway, Germany. They're all over the place that come into these communities to watch this. There's such an interest on it, which again, I agree with you saying, because of the type of crime it is. Now, obviously, about it, you followed it. And my question, if I can ask real quick, is as an attorney, what drew you to and your interest to this? Anything specific or just the case in general as an attorney?
Well, I'll ramble for a second or two, but number one, as an attorney in a case like that, you're immediately thinking, all right, this is going to be a death penalty case, right?
Yeah.
And you're wondering, who's going to represent him. Most death penalty cases, there aren't sufficient resources for parents or relatives or the client to afford you. So generally, it's going to be indigent defense appointments that do it, which has its advantages at times, frankly. But then secondly, I have twin daughters who they're going to be 37 in about 10 days.
Right.
But one went to University of Idaho and the other went to Washington State University.
Okay.
And then the one from Washington State University went to Gonzaga Law School, and she's a criminal defense attorney. Awesome. The one that graduated from University of Idaho in communications entered a master's program at Washington State University. Speaking of journalists, it's the Edwin R. Murrow School of Communications, famous journalist. She received her master's. They immediately hired her, and she was a associate professor for, I think, 8 to 9 years in that college, and she was also their grad assistant. So what she would do is, along with the faculty members of the college, would help recruit do site visits and interview the graduate students for both the master's and the PhD programs. And then she would supervise those masters and PhDs as they were teaching, as Mr. Kohberger was. Of course, she was doing it in the communications college and not where Mr. Kohberger was. So I had a lot of knowledge, both of the geography, grad assistant. So I obviously one of the daughters going to University of Idaho. So that piqued my interest, I guess, even more.
Sure. Now, Logan, Kim, Mikey, any questions before I go forward?
Just real quick, and we don't have to get into the like super fine details of it. I'm just curious, have you ever worked a case where there was a leak of information? And if so, how detrimental was it to you working the case?
Great question.
Yeah, very good question. And the answer is yes, and fairly common. And it kind of ties into what you're talking about with investigative reporters, and I'll tie it in. Because sometimes when you'd be talking with them off the record, you could get information from them as well as them trying to get information from you. Because in most criminal cases, discovery is not available to them. The police reports aren't released yet. They're not subject to disclosure.
It's all about money.
So a lot of information that they're getting to begin with to call you up comes from the detective or from law enforcement or from the prosecutor's office, perhaps anonymously, but they're leaking it to investigative reporters who are then calling you to follow up on it. So you try to get the information from them.
Sure.
But back particularly to the question is yes. And it always seemed to me, and I may be paranoid, but if it's true, I guess you're not paranoid, is that it would always seem in the older days that if it was a significant case of interest with a trial jury selection starting on a Monday, that on the Sunday newspaper, there'd be a section in the regional highlighting this, case going to trial and having all the information about, the client, how the killing occurred. I mean, very negative.
So just blast you the night before, pretty much.
Yeah. And so you're going into court saying, Judge, there just was this newspaper article. This publicity is impacting the right to fair trial. I want a continuance.
Yeah. Oh, wow. That looks like new
which
evidence.
Generally, generally routinely denied. The court would say, well, we'll start with the jury pool and we'll see if anybody of them have read it or if they've been impacted by it. And you knew what that meant. Some of them would say, yes, I saw it, but, I can still be fair and impartial. And other people would say, I didn't see it. And the judge would say, motion for a continuance or change of venue is denied. And on you would go. So, I mean, the bigger the case, the bigger the publicity regarding the leaks in this case. And I presume you're talking about the Dateline episode that aired with that additional information that wasn't known to the public when you're talking about the leak here.
Yes.
Kind of surprising. I've never had a case like that where it's not, it's been a newspaper article, not a national TV program.
Right.
And so it's not unusual for leaks to happen.
Of course.
And usually when it does happen, it's close to the trial date. Mm-hmm. This one was kind of exceptional in the nature of the leak.
So I guess a funny question is, how many acquaintances have you lost on a Monday morning?
But you've kind of, to an extent, come to suspect. And, if you've been in the journalism field or media field, that, on high-profile cases and even high-profile cases in smaller areas, there's a relationship between the media and the police. So, that's where the perp walk comes from, right? The police tip off a journalist that we're going to do the arrest. And all of a sudden, there you are with cameras and everything. So it's just part of the business and it happens.
Right. So when you first saw Kevin, if I can ask this, and again, any questions you're not comfortable asking, just let us know. I'm not comfortable going in that direction.
Sure.
Because we absolutely understand your position on some things. As you first saw this case released to the world, so on and so forth, when it came about, and you got the basic details in the very beginning. What were your thoughts about this, if I can ask you, and what did you expect to see from this case from that point?
Well, that's a good question. There's a lot of facets to it. I mean, the first thing,
Right.
obviously, I don't even think you have to have children, but having children who went to college and went to colleges there,
Of
I
course.
mean, you're just struck by the overwhelming sadness and tragedy of it. Saying this is
Yes.
just surreal. It's just like a worse than a bad dream, the parents' worst nightmare. So trying to struggle past those emotions initially, the next thing from a legal standpoint is you wonder, who did it? Was it one person? Were there more? You're
Right.
wondering what the motivation is, uh, and is there a backstory that's going to come out pretty quickly regarding somebody having a restraining order or a relationship that's, gone
Right.
sour? Because, I mean, a lot of homicides are, through people that know each other. And, but here you're wondering, wow, four victims. You're wondering, was the whole house targeted? Was one person targeted? It would not seem to be just a random off the street, somebody coming into a house and killing four. So, I mean, that's what's going through your mind is, gee, how could this happen? Who was it, or who are they? And what type of evidence is going to be left behind? And then as a lawyer, wondering, who's going to end up representing them and other things. But those are the initial thoughts that go through when you,
Of course. Yeah.
when I heard about the case.
Now, when you heard as it progressed and you heard that it took 8 hours for somebody to contact 911 and the things like that started to file out, what did you have any thoughts on that at that point?
Well, that seemed, really odd. We were getting, I don't know if we were getting a little more information than the rest of the country at that point, but I think we might have been. And, it was very confusing.
Yeah.
And at that time, you weren't even sure if the initial reports you were getting were really accurate. I mean, there was, talk that there had been a fair amount of communication and other people or other friends on scene before law enforcement, before medical, before first responders. So there was just a lot of questions. Is this accurate at
Right.
all? And just kind of waiting to see what came out officially and then trying to digest it then. Obviously, we've had a lot of time since then to contemplate, and there's still, I think a lot of questions regarding that gap.
Of course. Yeah. Yeah, definitely. I do have a quick question back and just taking a step back real quick that I did want to ask. Uh, somebody had asked, did your daughter ever have any experiences at WSU with any kind of students formally complaining about TAs or anything like that you can remember?
Well, nothing of this magnitude. I mean, there's, within the program, there's some students who don't think some of the teaching assistants are very good at communicating
Of course.
their assignments or how they teach. But no, there was nothing of a nature outside of the academic of it that really came to mind.
Sure. Absolutely. Logan, Kim, Mike?
I had a question about discovery. So getting discovery.
Yes.
And you're probably already familiar, but lots of creators on YouTube have been FOIA requesting information, things like that, following every single court hearing, like really have a close eye on this case, right? So it seems like it's a constant issue. That's what it appears like to me, with the defense having issues getting discovery from prosecution. To me, it seems like a system issue. And I wanted to know your thoughts on that. Like, why is there such a challenge, and why is the system set up like that? And are there any recommendations for changing that if you think that's necessary?
Well, that probably could be a mini series. I'll try to short circuit it.
Right.
Basically, just to explain, discovery is the exchange of information between the prosecutor and the defense attorney. And there are court rules that dictate what the prosecutor has to turn over to the defense attorney and what the defense attorney must turn over to the prosecutor. Most people aren't aware that the obligations are not the same. The prosecutor's responsibilities to the defense are different than the defense responsibilities to the prosecutor. But those are outlined in the court rules, and the prosecutor is required at a minimum to provide to the defense. Most states don't require that all of the police reports be given to them, but most states do it because to try to parse out from all of the investigative reports and forensic reports and etc. what is required and what is not takes more time than simply just sending everything over the defense. But
Right.
they have an obligation to turn over basically all information that they have that points to the guilt or potential guilt. All witness statements, who their witnesses are going to be, basically what their testimony is going to be, any results of any scientific tests, experiments, etc. That they conducted, whether they intend to use them at trial or not. There's exculpatory evidence, better known now as the Brady rule, which means any evidence that would tend to exculpate your client needs to be turned over. So that goes to other people they investigated and then determined were, not really suspects or didn't pan out, but you're supposed to be getting all of that so you can follow up on it. And then, of course, I think I already said, the experts are going to call at trial.
Yes.
Defense is required to also give their witnesses who they intend to call. They're required to give their defense, which basically means either I didn't do it, or you can't prove I did it. But more particularly, if you're going to rely on an alibi, you have to outline that beforehand and provide the alibi information. If you're going to rely on a mental defense, insanity or diminished capacity, in that case, you are required not only to reveal that defense, but you're required to give to them any testing done by any of the experts, whether you're going to call them at trial or not. Now, if the defense conducts their own independent forensics, you get a forensic expert. Even if you want to do a lie detector, you want to have a doctor come in or unrelated to a diminished capacity. If you don't like the results of those things, there's no requirement you hand them over like there is that the state must hand over to you anything they've done, whether they intend to use it or not.
Right.
So the defense responsibilities are much more limited, and you're allowed to, maintain much tighter grip on what information that you've done as a defense attorney gets out to the state or to the public. So you always have these battles going back and forth with primarily the defense saying, listen, I don't think I've gotten their whole file. There's something else in this file that relates to another statement or to another witness or to a test or to an event. I don't have anything about it, or I don't have it in the form. If I have pictures, I know that with the pictures now, that's going to have time stamps and dates. Just for example, I don't have that. And different prosecutors in different offices have a different view as to what really they're required to provide. So you get into these discovery battles quite often as to whether they're required to provide certain things or whether they've done a diligent search. And I guess the most important thing I should have started with this is it's not only what's in the prosecutor's control themselves, but they have an obligation to go to their investigating officers in the police departments and really kind of go through their files to make sure they've provided what they're required to be provided. They can't say, well, listen, this is all I got from the Idaho State Police. They're supposed to go back to the Idaho State Police and confirm, yeah, I have your complete file on this. So they're held to the standard that they have constructive knowledge of what's in law enforcement files, and they're required to provide that.
That was literally said in court by the prosecution.
Right.
In this case, they literally said that. Like, well, we can't give you what we don't have.
Word for word. I'm not even going to go into that. But
And just
I guess my response.
Yeah.
They don't understand what quote you means in the context of discovery.
Yeah. What was that, Kim? I didn't mean to cut you off on.
One more quick, oh gosh, I don't know if I lose my train of thought.
I'm sorry.
Oh, so one quick thing with this case. So the defense was still filing for discovery up to right before the plea deal, and then didn't receive, I believe, some of the discovery after the plea deal.
I think even after the sentencing, I think they didn't get
Sentencing,
anything.
yes.
Yeah.
Yeah.
Even the crime scene pictures, when they just came out, they didn't see them up until then.
That's how we were made to understand that. Yeah.
Yeah.
Is that a normal, like, on the defense side of things? Is that normal, or is that something that you would be, obviously you'd be upset about it, but would you expect that?
Yeah.
Well, yeah, I would be very surprised if it was in one of my cases. When you're looking at the initial police reports and you're getting them, there's generally going to be certain things that you're very interested in.
Yeah.
I mean, obviously, any evidence seized is going to be on an evidence log, and it's going to be maintained individually as to what they took from the crime scene.
Mm-hmm.
There should be a picture log, which documents every picture that was taken by number.
Right.
There would be a crime scene log that would contain the names of everybody that entered the crime scene, what time they entered, what time they left. So all of those, when you're putting your initial witness list, exhibit list, or just even in your mind doing it from the very beginning, you are doing a checklist of, do I, in later discovery, you might get the log first. But you're saying, all right, do I have pictures 1 through 700? There are going to be a lot of pictures of this crime scene. On the crime scene log, there's, let's say 30, 45 people, including, police officers, first responders, etc. So do I have reports and statements from each of those people? Sometimes it's nothing more than I'm Officer Curtis, and I was called to secure the scene, and I stood on the perimeter from 6 o'clock to 8 o'clock.
The perimeter.
And I went home.
Right.
Whatever. So it might be as innocuous as that. And then obviously the leads and the ones that are in the house looking at evidence, photographing the scene, etc., are going to have more extensive reports. So if there were crime scene photographs that weren't provided to the defense, number one, I would imagine the defense would have or should have known of the existence of them for quite some time, and or demanded a complete picture log, so they could go to the judge and say, hey, listen, I don't have 37, I don't have 46, I don't have whatever. But usually you go to the prosecutor first, and they might say something like, yeah, I'm sorry, 47 was a duplicate of 46, or this one just didn't come out, that's why it wasn't there. But you try to work that out. You should know that relatively early on, I would surmise.
Got you.
Have you ever seen, or how common is it for a prosecutor to enter the crime scene before a coroner or before anybody, really?
Well, not taking you literally. It would be unusual if they were the first one there. It's not unusual. I mean, prosecutors on call for high-profile cases or homicides and vehicular homicides. So it's not unusual for the prosecutor to be called onto the scene by the law enforcement, so they can be advising them as to what they can or can't do, whether they can search, whether they can get into the vehicle, whether they can go into the house, or exactly how they should proceed. So that's very common.
And I
not
think
the first one on the scene.
Right. No, of course. I think that question was asked because, and a lot of us have asked that, is a great question too, Logan. Because we know that the coroner was there on scene, staged like the next road over at like 12:30, 1 o'clock that afternoon. And throughout the day, she even made the statement she was letting the police do what they needed to do, which we, reading the laws, the rules and stuff, again, we're not professionals. We're just trying to understand. And she didn't go in the house till 8:30, 9 o'clock that night, when she was there all day waiting, because the prosecutor had to go in at 5. I think the prosecutor went in around 5, along with law enforcement, so on and so forth. And then she went in after all that. And I think all of us were like, me being a first responder, I was shocked because I've never seen it like that before. I've always seen the coroner goes in and then everybody that's going to do this and that. But this, again, I've never seen a case this big. So
We're
you know,
talking like 8 hours later.
Yeah.
Like she didn't go in for like 8 hours.
it was a long time.
Kim, it was their biggest
Yeah,
case.
that is a long time. Yeah, well, a couple possible explanations, and I don't know. I mean, I'm just speculating, and I'm
Of
really
course,
not
of course.
all that well versed in it. I know that, number one, it's evident that that the victims, are not alive.
Of course.
The next question is going to be from even, some of the lead investigators are relatively experienced. I mean, do they have a pretty good idea already as to time of death? And is it going to be significant from the coroner's standpoint, whether a 2 or 3 or 4 hour delay in seeing the bodies and seeing the position of them, et cetera, is going to be all that relevant as to manner of death? My guess is, and again, just a guess, is that the police detectives were, whoever came in there initially assessing the situation, were pretty sure what the manner of death, what caused it. And from a timing, they probably believe that they could put that together. I think the biggest concerns in terms of the crime scenes and entry are, we want to have our forensic team in there, and the fewer people that are in there while we're doing our forensic sweep for DNA evidence, hair, fingerprints, etc., the less people that are already inside can affect what type of trace evidence gets left. So, but again, I'm just speculating into that.
No, of course. And I think one of the reasons why that was asked, you kind of hit on it just a little bit, was because the coroner gave the time of death as 12 noon. And we all know it wasn't. And that was based on the time, basically, from my understanding, as the police response, because that's when they got there, roughly. Okay. So I think that's why a lot of people questioned that, because it was just off. You know what I mean? It was a little different from what we would see in most cases. So I think that's part of where that comes from. I did have, there was there it is, a question that was attached to another question from before that I wanted to back up just a tinge to get an answer off this possibly too. When Logan had asked you about working in and around the leaks and stuff like that during trials, and this was just somebody was curious from your experiences as an attorney, if you had ever had a chance to, well, probably it's not a chance, it makes it sound like it's a good thing, but working in or around what you believed as an attorney to be a corrupted situation, possibly. Has that ever been an experience you've ever had?
Well, yes. I mean, where you believe that perhaps your evidence is either being withheld from you, or whether you believe evidence has been tainted.
Yes.
Whether you believe witnesses may or may not have been intimidated by the police to either change what they may have initially said on scene, or whether they have attempted to dissuade them from talking to defense counsel or defense investigators.
Right.
Yeah, I mean, that's it is not uncommon to have those concerns that your case has been affected by state action, so to speak, in one sense or another.
Gotcha. So that's fairly normal to have to experience in some aspects as a defense attorney, correct?
I think it is, and I think more often than not, it relates to number one, discovery.
Yeah.
They're withholding something, and they've made the determination in their own mind that they don't believe that it's, quote, relevant or needs to be disclosed under the court rules. And as a defense attorney, you're saying, hey, listen, you don't get to decide that. Let's take it to the court, have them look at it ex parte, which means, in their chambers. And then they can say, listen, and then they can ask defense attorney, what do you think the possible relevancy could be? And you can talk with the judge ex parte in chambers to explain kind of your theory,
of course,
without the prosecutor sitting in there. And then the court can make a determination. So that happens fairly often as it relates to, what evidence or what materials are discoverable or not. And it's, with witnesses too, whether they've been talked to or been suggested they not talk with you, or a change of word or two, that happens. It's less common to believe that evidence has been tainted or has been removed.
Okay.
But there are cases where, yeah, you have suspicions that something's off.
Of course. Let me see. Logan, Kim, Mike, anybody? Before I ask any of these other ones.
Have you ever had any cases that were involving either sorority or fraternity members?
I have,
Good one.
and just go back to the last question. I was thinking of different things. For example, if you have somebody's body cam that's on for 4 hours, and then they're starting to interview a subject, and that goes blank for a half hour, and they say, "Oh, gee, our battery went dead," or something.
Right.
Yeah.
You had a scratch in your head. But back to the question, I have handled cases, but those have been, I haven't had one like this. I've handled cases that involve felonies involving fights, attorneys.
Sure.
Now, in going into those
raping and
cases,
harassment. Yeah.
Have you said to yourself, okay, we're dealing, with the sorority or the fraternity, this is going to be a little different? Is that just something that's ever just kind of come up in your mind that, if you know what I mean, you know what I mean?
No, I'm not exactly sure. I mean, I do know from my knowledge of Greek life that
Yeah.
depending on what type of case it is, I mean, I know this, for example, there's a fight at a fraternity party. Somebody wanted to get in. The fraternity says it's just closed to other guys. Next thing you know, you've got a big fight on your hands. I know to myself, all right, listen, we're going to have about 30 friggin' witnesses on this thing. Most of them are going to be intoxicated. I'm going to get very many different stories. I'm going to get maybe shut down from the national fraternity from interviewing witnesses. So, I mean, from those type of things, but I'm not quite sure if that's kind of your
I guess I led you into that on purpose so that, basically your experience, what you said,
sure.
you kind of know what to kind of expect. So,
yeah. And I don't mean it to sound this way, but when I get a call and somebody says, this is the type of case, what are you going to charge? Sometimes I charge a flat fee. Sometimes I charge an hourly fee. And before I give them a number on either of those, I try to figure out how much time is this case going to take. I mean, it's not the nature of the case. It could be a second-degree assault, a felony assault. But if it's a one-on-one and there's a camera in the bar that shows it and nobody else in there, I've got two witnesses, I got a camera as to what happened, what was said. That's a lot different than something that occurs in front of a large group of people. If there's a large police response, that means I'm going to have hundreds of hours of body cams. Some of it might just be nothing. I've got to know, do we have potential suppression motions? Do we have DNA evidence? Do we have forensic experts? So you're just kind of going through that in your head. So if you're talking something that happens at a fraternity or sorority, you're trying to figure out what the number of people involved or witnesses are in particular, and recognizing you're going to have fraternity officers and maybe national getting involved to some extent as well.
Real quick, and this is something I forgot from earlier too. When Kim had touched on the FOIA, a lot of the people that were FOIA and the information coming out of this case, so on and so forth. Is it normal? And what are your thoughts? I guess there's two questions, I guess, in one. There's a lot of very high pricing that has been tagged to these FOIAs. And I mean, I've seen it go as high. What was the highest one we saw, you guys? It was like $18,000 or something like that, or 14 in the realm of this to get.
I think for everything, right? For everything.
Yeah, I think that was the highest for that one, but like very high pricing on some of these documents to have these FOIA. And I think there was stated one time that it was because that was for people that were outside of the state of Idaho, blah, 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 so on and so forth. Is this normal? And is it like, you see
bringing
this regularly?
Attorneys to have to review everything for the redactions and
some of it's not voluminous. Like someone paid like, I don't know, $800 for like a 12-minute video that was like heavily redacted anyways.
Very heavily.
Yeah, I think there could be some pretty fair criticism leveled at the way the information was maintained and distributed or not distributed and the costs associated with it. I'm
Right.
not an
Right.
expert in that field, but
Does that sound
I
legal?
don't think it was handled well.
Gotcha. And like Kim just said, does it seem or sound legal? I guess, for lack of better terms, at that point, from your point of view. And again, if you're not comfortable answering something, you don't have to.
Well, it's a pretty gray area as to whether the agencies providing the information are allowed to factor in some of their time, et cetera, that goes into the man hours to put this together versus their duties. I mean, obviously, that's part of their duties is, a records department maintains the records. But, when you do have a case of this magnitude and a lot of information, along with, in the old days, I don't they still do it, charge, like 25 cents a copy or 50 cents a copy when, their
Right.
copy machine does it for 1/10
Yeah.
of a cent. And reproducing a video, how long does that take, and the man hours and what they can charge for? It's a pretty gray area.
Sure.
So, for the most part, the people need it who are requesting it generally are, journalists and media, and they need it relatively quickly enough, and they don't have time to go to court and squabble over the cost, or they won't
Of
get
course.
it.
Of
So
course.
I don't think a lot of it ends up in litigation.
Gotcha. Gotcha. Thank you for that. We've all wondered that. I know that for a fact because some of it just didn't make any sense. And then we're told that once it's been done by one person, then you're just paying the duplicate fee. And like Mike had said, the response to the reasoning why it was done was, well, we have to pay attorneys to do this and to review that, and this has to be redacted and to do this and that, and all the basically things that like a lot of people that live around this area have stated. Like, I thought we paid taxes for these things to have been done already, so on and so forth. But I guess I know it's certain special circumstances. If they're giving it to a specific person, they have to look at it before they do that. I understand, but I kind of
Yeah.
thought that was all already done. You know what I mean?
Like
So-
Kim has an
Well,
interesting case with the stuff that you had got from Prince, right? Which is, what
Yeah,
I'm saying?
when his
Yeah.
case was closed, I believe it was just all put on the website. Like, and that's a super high megastar person. Yeah.
Yeah, that was an interesting
Yeah.
situation.
Or even FOIA, when you did a FOIA request, you got even autopsy results, his actual photos, right? Laying in front of the elevator. Like, you can actually see him, and he's who he is, and
Yeah.
the comparison between what's going on in both cases just doesn't make sense.
And yeah, they're just like dripping little bits and pieces of information as they can when they feel like it at some point, I guess. That's like she said in a lot of other cases we've covered and stuff. It's just there. There you go. There it is, and you move along. You know what I mean? That's one of the weird things too.
Well, are we talking the Kohberger case or the Epstein case?
Yes. The Kohberger case. I'm sorry.
Oh, you stop it, Kevin.
That was good.
I stop it.
One.
All right. In Spokane, where majority of my practice is, and I'll just say as an aside, when you talk about discovery, go way back, the federal rules on discovery are really, really different.
Sure.
If you want to talk about getting blindsided in federal court, a lot of their stuff they don't have to give to you until the night before that person's testimony.
Oh wow.
So that's another
sure.
Monday morning
It's a-
deal.
The federal system is very, very different. Regardless, going back to this, in Spokane, generally on high-profile cases, the records department will put together a package so that, when KHQ comes by, or here's your package, CREM, here's your package. I don't think they charge. If they charge, they charge minimally. It's generally they have it, prepared. Once they have it prepared anyway, they put it out and they just have one package ready to go to everybody. So the way it comes out in pieces, and it may have to do with the size of the material here as well. And it's rural. They don't have, that county doesn't have a lot of resources,
Right.
so to speak, compared to larger cities. So, but I think it could have been handled better. It probably should have been anticipated much earlier, and the redactions occurring with an eye
Yeah.
towards public release much earlier than was done.
That's what I thought too. I did have a question for you, and almost a personal question, not personal, but if you were okay, let me phrase it this way. Let's say, for instance, you were covering a specific case, something that was like this, okay? And
Okay.
as a defense attorney, you're getting this information about certain parts of the case, like DNA samples, for instance, were put into a refrigerator. The door was left open on the refrigerator. They went bad. Then there's a fire at a records facility that burnt up information for that you would have needed at some point. And things are being lost over here, and things are being lost over there. And this person's testimony doesn't exist. There's a thumbnail drive that had information that just disappeared. I mean, as a defense attorney covering this
Video with
case,
no audio.
yeah, videos coming to people with no audio, things like that. What would your reaction to something like that be, Kevin? Just out of curiosity.
Assuming I'm the lawyer on the case, or just hearing about it,
The
or
defense attorney, yes, sir.
yeah. Well, first of all, when you're talking about any type of forensic evidence, we'll use DNA as an example, but you can use it for weapons and other things like that. I mean, one of the things that you're looking at was, first of all, was it properly collected? What I mean by that is twofold. Number one, legally. I mean, did they have a legal right to go in there and seize it? The general rule is, stuff taken without a warrant is inadmissible. And then there are the exceptions to the warrant requirements, So you're analyzing the legality of it, first of all. I mean, was the initial search or seizure of it legal? Yeah. Secondly, was it, were the proper procedures followed from the time they saw the item? Did they photograph it before they touched it? These are just examples, when they, how did they put it into the plastic bag or into the evidence locker or whatever? I mean, did they properly use gloves? Did they use a I mean, how did they pick it up? How did they put it in the bag? Did they seal it? Did they, write the information when it was seized? So you're looking at the whole chain of custody of the item, and that includes, taking it in, getting it to the experts to examine it, the expert's examination, the lab the expert examined it at, if it's a state lab, in Washington State, we had some serious issues, whether there was contamination within the drug testing area or methamphetamine was found within the lab on various equipments. So you're looking at that. You look and you want to pull the certifications. Do they have annual certifications, reviews to make sure they were using proper procedures? As a defense attorney, you don't know the ins and outs of all of those things, but you do know enough when you get the lab reports to be having an expert reviewing them for you and seeing if they see anything. You can review the chain of custody and see who it went to and see if there's a break in the chain. But as the actual procedures, do they have videos of them retrieving the evidence? So if you're looking and then you're seeing that there's a lot of discrepancies or issues, then the next question is, all right, from an admissibility standpoint, what does this do? Is this sufficient for the court to rule that it's unreliable evidence and thus can't be admitted? Or is the judge going to say, well, listen, you can inquire about it and bring it out, but I think it goes to the weight of the evidence in front of the jury. It doesn't go to the admissibility of the evidence. So those are the kind of the processes that you go through when you're analyzing what you believe to be problems with evidence seized. Does it go to the foundational introduction in which they can't lay a proper foundation to admit it? Or is it sloppy, in which case, part of many cases is that there was sloppy, poor investigative work?
I have a question. I'm very curious, how well do you think Ann Taylor did defending Bryan Kohberger? And is there anything specific that you would have done differently?
Good question.
Great question. Was going to ask that myself. Thank you, Logan.
I thought I've been asked that before, and first I'm going to qualify it, and I guess maybe take a coward's way out, is that, unless you're in there, I mean, I haven't had time to go through all the information that's, within there. I don't know everything she saw. I don't know her conversations with her client who dictate certain things.
Of course.
So without knowing that, you can only talk in a general sense. And in a general sense, I thought she did a good job. I mean, it appears to
Right.
me that she got, she got the right people who had the right credentials involved, both from an attorney standpoint, a mitigation standpoint, from an expert standpoint. She attempted to suppress, I think, the evidence that you knew you had to suppress to even have a chance at trial.
Sure.
And that is the DNA. So, I mean, she challenged that, at many levels, in terms of its reliability and the type of the genealogy, the genetic connection, the seizure, and how they got there. So she tried to keep the DNA out as best she could. And if you couldn't, you would just be arguing that, it's pretty easy to transfer that type of DNA on something. So she filed the right type of motions, arguing the death penalty is unconstitutional, trying to attack the grand jury. Those are all issues that you, for the most part, knew weren't going to go anywhere at this level, but you're hoping down the line you're going to get somewhere, if not even in the Idaho Supreme Court, maybe in the U.S. Supreme Court. You're pretty sure the Idaho Supreme Court isn't going to change much, but there can be substantial swings in the U.S. Supreme Court as it relates to death penalty and constitutionality, et cetera. So, I mean, I think she did a good job on that. And in death penalty cases, the mantra generally is if you can get the death penalty taken off the table, it's been a very successful defense. So, I mean, she got that done as well. So overall, I think I'd give her a good solid B plus on that.
Absolutely.
There are individual things that I thought were interesting. And I don't know, the change of venue.
Right.
Is interesting. I mean, you can understand initially you're going to say, oh my God, it's in this community where the college is, the first responders are, and it's small. But you sometimes have to be careful what you ask for.
Agreed. As we saw.
She knows Judge, and for those who don't know, that is his last name.
Yeah.
Is a very conscientious. Yeah. He's a very conscientious guy.
Right.
And he also knows, Miss Taylor and the office, it's actually at that time Kootenai County Public Defender's Office.
Right.
Which Kootenai County is in Coeur d'Alene, but they contract out to perform public defense for Latah County. Go ahead.
I did not want to interrupt you, but I wanted to point something out since you said that, because I noticed in one of the final hearings between her and Judge, he made mention, she was pointing out the issues that she was having along with prosecution up to that point and how bad they were. And Judge looked right back at her and said, no, Miss Taylor, I do see them and I feel for you. Those were his words. And I went, wow, that was kind of interesting to me, because there were so many things going on, Kevin, as I'm sure you probably saw, that were just not on the table, level on table. You know what I mean? And he pointed out, noticed it, and we didn't expect, because all of us here that were watching this expected the change of venue to bring forth the better option for a fair trial. In turn, you know what I mean? So
close it up quick.
Yes. Yeah.
Yeah. Let's go back to be careful what you ask for. So,
exactly.
It's part of a no-win situation in some sense. I mean, in some sense that it makes sense to get a change of venue. But on the other hand, you don't know who you're going to get. Most likely, you probably would have factored that case is going to Boise, not Coeur d'Alene. Those are really the only two facilities that might have had, the courtroom size and the ability to get in and out for all the experts and witnesses with Spokane International Airport and Boise's International Airport. You're not going to go to another county, and then you don't know who you're going to pull out of that group, and you may be a lot worse than who you have. And I think she would have gotten a lot more considerations on some of the pretrial pleadings and motions than the judge in Boise gave. I mean, again,
when you're on the other side, Kevin, and you're not presenting stuff to where this is actually going to go to trial, that's funny how that comes into play. The planning of, the airports and the da-da-da. So,
Right. Well, you address that in your motions for venue change, because when you look at the
Yeah.
law on venue change, the court has to consider, I'll make it up 5 primary factors, and they include this, 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 this. And that is one of the factors. And in this case, you're going to have a lot of people number one, you're going to have a lot of people from Latah County that have to travel to Boise, which is, I don't know, 6-8 hours away. You're going to have a lot of experts, and they have to be flown in. So you don't want to move it to another neighboring county where they've got to fly into an airport and then travel 3, 4, 5 hours. You're going to have national media. Where are they going to stay? There's no 4 Seasons in Latah County.
Of course.
So that, outside of the other issues of prejudice and fair trial, you have logistics that do come into play as to if you are going to change venue. Why are the facilities there? Why are they insufficient? Were you asking it to move to sufficient? So it's just a factor.
Unfortunately, it's kind of like drawing a number out of a hat and hoping that you get the best number, from what it seemed to turn out to be. And I don't think any of us expected it to go the way we did when Judge Hippler was presented to the day that we first met him, and he's sitting there going, I don't want to start this off with an untruth and tell you that I'm happy to be here. Everybody kind of went, whoa, wait a minute. Something's not going to be right with this, And at that point forward, it just became, what is going on? And that was part of the other part of the question I was going to ask you, as far as do you feel, and again, if you're uncomfortable answering, I completely understand. When Ms. Taylor asked for the continuance, the third party defense and the alternate suspects, whatever you want to ask, all of this, it seems as though there was denial through everything. Do you have any feelings personally towards that? Say, for instance, if you were in that situation, how you would have felt you were being treated?
I haven't looked at, and I did, I think 5 or 6 segments with Andrew at various times during the case. And I certainly remember that issue. I don't, off the top of my head, remember a lot of the other issues.
Right.
But I will say this. He made short thrift of many of her arguments, and it was pretty clear.
Yes.
Even when he said, I'm going to take this issue under consideration, it was pretty clear from the dialogue going back and forth during the oral hearings, he was not inclined to see it the way the defense saw it. I think he did make the correct ruling on the alternate suspect. You can't just say, basically, vaguely, generally, somebody else could have done it. Yeah, the standard for introducing alternate suspect is, again, a list of factors, and they were a little bit thin on them. But
I think his response to that had something to do with, like, but they don't drive a white Elantra or something like that. Do you think that? do you think that was proper for him to say? In your opinion, of course.
In my opinion, he was pretty dismissive of some of the defense arguments, and he didn't have to be. Many judges would listen intently, and then just make a ruling saying, I'm not, I listened to this, I listened to that, they have this. You always know you're really not going to win a motion when the court starts saying, God, Mr. Curtis, you made some really good points with A, B, and C.
But right. Yeah. That big but.
But yeah, he appeared to be irritated. We go back to Ann. He seemed to be irritated with her. I think some of the pleadings I thought were a little aggressive. I probably would have toned down some of the pleadings, recognizing that, particularly when I'm now not in an area where I'm familiar with the court, the judge.
Yeah.
And now I'm in Boise. I'm going to tread a little carefully. I know it's a death penalty case, but he knows it is too. And I think there's a certain amount of respect and decorum that you need to give even on the pleadings and not get in. And then, Bill Thompson did some of the same thing in his responses too. And that doesn't please a lot of judges, particularly when they're not having to deal with these people.
Yeah, of course.
Later on.
I wanted to ask kind of that same question, like same line of thinking, but more like a hypothetical. So with some more specifics, So you find yourself in front of a judge that you're not familiar with, maybe, and they're interrupting you constantly. They are arguing for the state practically. Like the state doesn't really have to say anything because the judge is saying it for them. The judge is always ruling for the prosecution, and then also making snarky comments like, not, well, the ultimate perpetrators don't drive a white car or whatever, and also calls one of your experts a conspiracy theorist. So if that hypothetically happened, what would you do? Like, are there any actions a defense attorney can take when they think you have like a possible alleged maybe biases going on?
Right. Well, what you would do in that case is that, I mean, a couple different strategies, so to speak. I mean, theoretically, you can attempt to quote bait them a little bit more and see if you can create even a stronger record for it. But your remedy really is to file a motion asking the judge to recuse themselves and, putting on the record, all of those comments that you made, looking at the body language when he's listening to arguments. You're doing that, you're not going to have the case recused, and you're setting up the record for down the line, hoping somebody will see it, but it's going to have to be pretty powerful. I mean, by doing that, of course, if you ever had the judge in any corner, you know that you've destroyed that relationship by bringing that motion.
Yeah.
You've got to weigh, is it worth bringing that motion? Knowing that the short term it's going to be a disaster, but theoretically, I'm not winning this case at this trial level anyway. So it's worth it to put it together and put it on the record or not. So that's just a strategy decision that you have to make, and it's difficult. You're making hundreds of strategy calls, even during the briefings, pleadings, oral arguments, etc., all the time. So that's something you just have to weigh.
Yeah.
From my standpoint, what happened would not have been sufficient for a higher court, state or federal, to come back and say, yeah, the record is so clear it was prejudice against them, that we're going to throw this out. That's just my guess. But
Yeah.
Right.
Thank you. That was very interesting. Very great information.
Absolutely. Logan?
My question is, if you were the attorney for Bryan Kohberger and where the case was kind of heading with the hypothetical bias and things like that within the courtroom, do you think advising him to take the plea deal was his best option, or would you have advised him to take a different route?
wow, what a great question. And I don't know if I'm going to be
Absolutely.
able to give you a great answer.
You stop it, Kevin.
Yeah.
Well, we'll take a swing. Every relationship you have with a client, and even high profile ones, are, really different. I don't know. It appears, at least from what we would see on camera, that they had a very good relationship. I mean, some people even questioned that she was almost too close to him during the hearings, and that it didn't, you always want to show that your client's human and that you respect your client and try to present them in the best light. But they appeared to be very close. But outside of the optics of that, if they had a good, full, open communication, you're still leaving it to the clients. I mean, that's the ultimate decision. It's not your decision. You need to earn the trust of your client, saying, listen, here's what I foresee based on the best of my experience. If we do A or B or C or D, here's going to be the outcome of A, of B, of C, of D. So you're going both ways, answering questions they have. But in this case, you're certainly not trying to pull or push them in any one direction at all. You're just trying to be the best information source for that client that you can be, to allow them to make the decision that they're going to be most comfortable with in the long term.
And I agree with what you said. I noticed, I think a lot of us did, that it seemed like most of his team, including Eliza Massive, it seemed that they had, and I know as a defense attorney, that's part of your job to some extreme, but you don't have to believe in what you're fighting against either. And it seemed that they did believe in his innocence, in my opinion, from what a lot of us saw and took into effect with what their actions showed. So I so what you're saying is that's not always a good thing in some aspects as far as the close relationship side of things when it comes to that.
It's not, although I probably would, from a betting standpoint, more likely than not, there's going to be a claim down the line of ineffective assistance of counsel because that's what inmates file when they have, there'll be appeals, perhaps. I could be wrong, but he may make a collateral attack on the plea at a later time, saying, "I didn't know this. The state withheld evidence. My attorney
Sure.
didn't know this, or my attorney didn't do that." I mean, that's possible.
Can that also, I don't mean to interrupt you, but this is another part to what you were I was actually getting ready to ask you the same thing. Can that be blamed on the judicial side, the judge in this portion of that, for causing the ineffective assistance of counsel?
No, I
interrupt
think
you, sir.
more likely, no, I really don't think you can go that far. Theoretically, you could, in an ineffective assistance, or we call it IAC claim,
Yeah.
ineffective assistance of counsel. In an IAC claim, in this particular case, if you're going to try to do it, you really have to put blame on the attorney for not filing for those judges.
Oh,
You
okay.
can't. I don't think you're going to be able to come back directly to the judge.
I think what we're thinking along the lines of, maybe, sorry, just to clarify, if, like, let's say it's Brady violations, right? Because discovery wasn't turned over or it's hidden or whatever. And so if your attorney didn't have it because of reasons like that, then can that be ineffective assistance of counsel?
Well, it can be grounds, it's generally a collateral attack. Since he can't appeal his plea, he can file a personal restraint petition. It's a PRP. And you generally have to allege grounds that you would not have been aware of at the time you entered the plea. So it's something that you found out after the fact that, had you known,
Gotcha.
would have changed the fact. So if you find out later that there's evidence that wasn't provided to your counsel, that's really not an ineffective assistance claim because they didn't have it either. That's habeas corpus from the standpoint of misconduct of the prosecutor that you didn't know of at the time.
Gotcha.
So those are the type of things that you could file a PRP claim on.
Gotcha.
If you're going for ineffective assistance, it's there were these motions that they didn't file, or that primary would be they either fell below the standard of care. Now the problem is there's a lot of problems with an ineffective assistance claim in this case because on the record, I didn't see that she was anywhere near below the standard of care for a death penalty case. So I don't think it's a viable or a winning one, but that has nothing to do whether inmates who have a life sentence in front of them aren't going to scribble something out and send it in.
Gotcha. Do you? I'm trying to throw in some of the questions from our chat as well. Do you feel that the university had any kind of an influence on this case at all, any way, shape, or form at all, Kevin?
The University of Idaho.
Idaho. Yeah, I'm sorry. I should have clarified. My apologies.
Oh no, that's all right. Well, I do. One issue which was very surprising to me was the destruction of the house, and obviously the University of Idaho played a substantial role in that decision. So from that standpoint, yes, and the defense must have thought they had gotten the biggest gift in the world when that happened.
Yeah.
It still surprises me that
both sides
the
were
prosecutor acquiesced to it. I think. If we're going to go back over the case, if it went to trial, depending on the outcome, I think that could have been a real strategic misstep by the prosecutor. So from that standpoint, yes, I do believe there was a substantial role played in that decision. Other than that, I'm really not aware of anything else. I'm sure they were not involved in the plea decision. They wouldn't be a proper party to discuss or negotiate or get their position on. That wouldn't be something they would have standing on.
Right.
Can
I-
can he
go ahead.
expand on that a little bit more? Like, I'm curious why, because I know me personally, I feel like there was a lot of value in the house for the defense, just like me personally. But so why do you see that automatically as like a win for the defense for the house to be gone?
I think that when 12 jurors leave the jury room and they are being driven over to the house that's the scene of a
Yeah.
mass homicide,
Yes.
every step in that house, I just think the emotion is an overwhelming emotion.
Against the defendant, right?
Yeah.
Not to
So
say-
I think you take a lot of that out when you are putting up, even a 3D or drawings or exhibits. Has nothing of the same impact as just being in that bedroom and saying this is where even if the blood stains out of it, they're going to be showing the pictures. If you're the prosecutor, you're going to be showing the pictures before you do the house tour, so you
Yeah.
can really drive home what that looked like that night. And I think that visual image of the pictures and the blood and being in the house, I just think that has
Yeah.
a huge emotional impact on the jury that you lose by presenting it in a different fashion.
It makes sense. It does. I'm gonna go a little to the left here with this, but I know this is a lot of people are asking this. I just got 3 emails about the same thing. So I'm sure you know some details of the case and that there were 2 surviving roommates, as they call them, so on and so forth, that were there that night, um, so on and so forth. So if, again, you're defending this case, you're defending the person involved, and this is something that you are approached with these 2 people, the statements that were given, a lot of that stuff has come to be untrue within their statements, so on and so forth. Of course, the PCA, the prosecutor himself said was irrelevant at this point. There was a lot of misinformation, but so on and so forth, all those things. What would be your, again, opinion, I guess you could say, of these 2 surviving, quote unquote, surviving roommates and their, how can I explain what I'm trying to say here? Their position in this situation. How would you approach that? What would be your worries with that, if anything at all?
Well, you have, I think, at least 2 different levels you'd be analyzing that from, just
Uh-huh.
off the top of my head. First of all, is the eyewitness identification. So, we know that, the allegation is that she saw an individual that basically matched the physical description of Kohberger. In other words, roughly in height and bushy eyebrows. I mean,
Right.
she seemed to believe it was a male. Um, and her, probably within that 5 to 10 minute area where she, heard something, heard what she thought was this statement, then saw the individual, that time frame, you would be, you know, tempting to demonstrate that it's unreliable. I mean, whatever she said or thought she heard or thought she saw at that time is simply unreliable. And it's unreliable when you look
Right.
at the context of what she did afterwards and the communication back and forth and why they didn't go, investigate, and why there were roughly 8 hours or 7.5 hours between that time and the time they call their friend. I mean, this doesn't make any sense. So
course.
you need to discredit as best you can that identification. And then secondly, we do know what the levels of alcohol, at least from the other group, was. I don't think we do know what it was from the 2 survivors.
Right.
But you, I guess, could infer that if they were in the same condition as the others, I mean, that just adds another layer of unreliability to their
Sure.
statements. So, and then it depends on what your defense theory is, really going to be. I guess to an extent, the theory was going to be this had to have been somebody else. Kohberger couldn't have done it.
Of course.
But really, the defense was there isn't sufficient evidence beyond a reasonable doubt that there's, a lot of circumstantial evidence, but none of it, when you boil each piece down, really points directly to him. I mean, that would be the defense thing. So you got to try to, you work with what you have from the facts, and some of those are bad facts, and you just have to try to piece by piece derail them.
So do you think that
you're the defense attorney?
No, of course, and thank you again for the. By the way, do you need to take a break or anything? Because where are we at now? We've been here. Yeah, we don't have too much longer. I don't like to keep you guys too long, but
no, I'm okay. If somebody else needs a break, that's fine.
Oh, okay. Does anybody up here need a break real quick?
That's a negative, sir.
Okay, Logan, you good? Good. Okay. So, do you think, Kevin? And this is again another opinionated answer, if anything. Do you think that the plea deal may have been part of the fact that the prosecution realized that, at least these are our opinions as well, that unreliable witness and maybe possibly the other one being put on the stand would have been on cross, would have been taken apart by the defense at some point? Because that's what I think a lot of us believe, that with what you just said, the unreliability of the whole situation is right there in our face. So, and I plus knowing what at the end of the whole thing, what he explained that their proof, quote unquote, was not much of anything, like kind of like in what you explained there. Do you think that may be why the direction the plea deal was put out there like that, or any thoughts?
No, I don't think it was a factor. I think they were pretty confident they would have gotten a conviction on the evidence.
Got you. Okay.
Particularly after the court. I mean, this plea came fairly quickly after the court had made the final rulings on the suppression evidence.
Yeah.
Which I think that was, the final hammer, which would allow the evidence coming in from the what they found on his computer and the Amazon search histories and the surveillance and the photos of other females. And, I can go through a litany of it. I don't think they had a fear of that. I mean, I think, number one, the family's victims were split. I guess there's always a chance you're not going to get a conviction.
Yeah.
But I don't think that was really a factor.
A factor in it. Okay.
In their case.
Thank you. I appreciate that.
One thing I do want to say, to be still the most confusing thing, and I can talk about the other issues if we want to talk about, some people say, listen, one person couldn't have done it.
Sure.
So I don't know if from that standpoint you say, so if you thought it was two people, do you think Mr. Kohberger was one of them? Because if so, he's still guilty. Unless you think it's two other totally unrelated people and he had nothing to do with it. And I'm not sure, the evidence that I've seen really bears out a two-person theory. Although, I mean, you can make a plausible argument for two people. It would be easier to explain the lack of physical evidence if you had people helping and getting rid of things, etc. Right outside of the house. Depending on what you wore. Obviously, you're going to be in hairnets and gloves and probably, wrappers over your shoes to keep trace evidence. But we can go into that if you want, or a different episode. To me, what I don't understand is this: because there are sufficient questions that one could raise about other people. How could it have occurred that quickly? How come other people, didn't wake up during it? Could have they done it at the time? In my experiences, and even with death penalty cases, before the state is going to take the death penalty off the table in a negotiation, they require you to sit down with the detectives and the prosecutor and basically, truthfully disclose how you committed the crime. And in this case, it would have been, initially from, who was your victim? How did you find that house? Were you looking at it before? Was it random, or what did you do? In terms of surveillance, how do you, was it your intent to kill more than one? Who was the subject of it? How did you do it? What did you wear? Where did you dispose of clothes? Where did you dispose
Why
of
did
the
you
knife?
do it? Yeah.
And if they're not, and on the why, you can't really, I don't know why, but
Sure.
And you're probably not going to get something that gives 100% accuracy. There's always going to be some level of guarding. But from the detectives and prosecutors, if they have substantial experience, you're going to know what has a ring of truth to it or not. And you're not looking for 100%. You're looking to get, from what you can tell, what really happened, when it was formed, how it was carried out, and why. And if you can give that to the victims and the victim's family, that's worth more than anything else in the long run.
Of course.
So
Of course.
I am still perplexed. I have not seen or heard anything as to why that was not a condition of taking the death penalty off the table and accepting the plea.
That was my next question too, actually. Yeah.
Is it normal to have that? Like in most cases, is that an expectation?
Yes.
Sorry.
In the cases that I've handled, in the death penalty cases I've handled, it's been, we won't consider it unless, we know this.
Yeah.
And it's twofold, actually. I mean, first of all, it helps satisfy their understanding that somebody isn't. I mean, there are cases where people confess to things they didn't do. So, number one, it verifies that you have the right person. But number two, in a case like this, it answers a lot of questions that the victims' families have a right to know.
And the response.
So
I'm sorry. Go ahead.
No, go ahead.
I was just going to say that the statement that the prosecution as well as the judge made about that was very far out there for me. I've never heard that. Like, you wouldn't understand if he were to explain this, and he doesn't. I've never heard a judge specifically or a prosecutor say that he's not going to be saying anything because of this reason, which is ridiculous to me, that because we wouldn't understand it or they wouldn't understand it or whoever wouldn't understand it anyway because it's so dark or something like that is what he said. I can't remember exactly word for word because I just was completely thrown by that.
Did you forget everybody over there is super nice?
Yeah, well, that too, but
He said we would have no way to verify if what he's telling us is true. The prosecutor said that. The prosecutor said that. So all the evidence they have that he's the guy, they wouldn't be able to prove that anything he said was true or not.
And then there was something about we wouldn't understand the depth of it, of his mind or something. Yeah, right. What he said along with that.
Isn't that the whole point?
Well, I can tell you this. Yeah. Well, it's impossible to know or verify if you don't ask, correct?
Yeah.
Oh, yeah. And they said he would lie anyway. That was the other part of it. He would be lying to you anyway. And we're like, okay, thank you for knowing that.
He's in this position
but
because he was a liar, quote unquote. Jeez, you got to be kidding me,
Yeah. Go ahead, Kevin. Sorry about that.
Yeah, obviously I disagree with that statement. I think, from even the crime scene itself and, what they found, forensically, even back from when he bought the knife 8 months ago to him going over prior to classes started in Idaho and some of his social encounters and through his cell phone when he was in the area. If you took him back through those things and required him to give you information about it, you could, for the most part, have a pretty good idea whether you're getting a straight story or not. And even the areas where you might not be getting a straight 100% accuracy story, you would have a pretty good idea. I mean, even the simple question of when did you first see any of these, how and when did you target them? Did you ever go to their workplace or did you ever do this? And you could put in some trick questions, so to speak, based on the evidence of things that may not be 100% relevant, but you could be testing, his memory and his level of deception by throwing some of those in. So I would strongly disagree with the suggestion that, seasoned law enforcement officers and detectives and seasoned prosecutors wouldn't be able to discern whether what he was saying had any level of truthfulness or not. I would strongly disagree with that.
Yeah.
Zero cross angles. Zero.
So, I know there's a lot of questions about you're familiar with the WSU lawsuit that is out right now against them. Okay.
I
So
am.
what are your thoughts? Let's start there, I guess, with that part of that. What do you think about this first and foremost about the whole situation? Do you have any thoughts on that at all?
Well, I think from a straight legal standpoint, it's a very, very, very big stretch. I mean, it is possible. There have been suits that have been successful against universities for actions by students that are, quote, under their, oh, sorry.
Oh, you okay?
Yeah, yeah. That are under their control, so to speak, through scholarships or housing, etc. Now, those have been limited to other attacks on other students at that same university. It's never been expanded to different areas. So it's a long, long reach and a long stretch. Legally, I don't think if it went all the way through to trial, I think it would be unsuccessful. I think the university would prevail. Whether it is being brought by the victims' families because they believe there's additional information maybe within Washington State University that I don't think was disclosed. And that helps them understand more. I don't know. But I think from, looking at the legal standards from a liability standpoint, from a Title IX violation, which is one cause of action, and then negligence, the others, I think they're going to fall short. They probably have enough to get past a summary judgment motion, which means if you look at all of the facts most favorable to the plaintiffs, is there a chance that a jury could find against them? If you take everything most favorable to them, yeah, they probably survive summary judgment. But once you get to the actual evidence at trial, can they meet the elements of a Title IX action or all of the elements of a negligence action, which include, that you first of all had a duty to those particular students, that you breached that duty by failing to take action, and that your failure to take action was the cause of the action. In other words, had they done this, this homicide wouldn't have occurred. And the plaintiff has to prove all of those elements, and there's a challenge to each one that I don't think the plaintiffs can meet from what I know at this point.
Got you. Oh Lord. Did anybody else have anything to add to that? Because I have another one about that.
I do.
Go ahead, Logan.
Well, I want to switch back to the regular Idaho case.
No,
rather
it's
than
fine.
lawsuit.
Go ahead. I know there's some stuff I was trying to grab and missed it.
Just real quick, working different kinds of cases, whether it's a murder case or not, if there are confidential informants involved in the case, whether it's a victim or maybe a witness, are they treated differently, or is there something done differently with them if they are confidential informants?
Well, you have a couple different types of confidential informants. You have confidential sources, CSs, you have confidential informants, CIs. Sometimes you have paid informants. So, both the prosecutor and the defense handle that differently in terms of what type of informant they are. I mean, if they're Joe Citizen versus, an inmate snitch, so to speak. I mean, there's different things you would do regarding both discovery and interview of them. I feel like I'm not answering your question very well.
I'll be more specific. Let's say one of the witnesses in the Idaho case was an informant, or even one of the victims was an informant. Would you see, like, if it was a witness though, would you see them treated any different, or would they not have to show up to court for anything? Would they be treated different noticeably at all?
Well, they might be treated differently pre-trial, to the extent that the state may be able to withhold their identity longer than they would other witnesses, or they may be able to get some protective orders in place. But again, it varies quite a bit. I mean, down the line, you would, as a defense attorney, be entitled to know, who they are. You'd be generally entitled to interview them. You'd be entitled to know whether they were paid or not paid for their testimony. you would do discovery to determine whether they had ever provided information to other police agencies or in other cases in the past. So, for example, were they working anything off? Was there a potential charge against them that wasn't going to be filed, or a charge against them that was going to be dismissed for their cooperation? So, I mean, those are the things that you would be looking at. If in the report it would say, I received a confidential communication that said X, Y, and Z, as a defense attorney, yeah, you'd immediately be following up the prosecutor saying, I want to know who that is, and I want to know their background, him or her, and I want to know if they've ever provided information before to this police department or to other police departments. So those are the things you would be doing.
Now, we know this case is still pretty much being hidden from us, and a lot of us have been sending in FOIAs and we're getting denied, specifically when it comes to the two roommates, the two surviving roommates.
Yeah,
Could
so.
we be being denied because they're confidential informants and that's why we're being denied for privacy?
Interesting.
Yeah, it could be. And I think the case for not revealing it perhaps gets stronger now that the case is over, because the person who's got the most compelling need for that information is the defendant, so they can get a fair trial. And so after that issue has been resolved with a plea, the question is, does releasing that information to the public and the public interest in that information outweighed by the privacy interest of the students or the individuals? And you can make a strong argument actually for both sides of that from a legal standpoint. I hate to be an in-the-middle person, but you can understand that, both from a public interest and media standpoint, that's necessary. I mean, the court system relies upon illumination and bringing things to light, but on the other hand, there's a strong privacy interest from people that have, been through what they've been through. So, I mean, that's a very difficult, one of the areas where it's very difficult from both a legal and a ethical standpoint as to where you weigh in on that. My assumption would be that the defense would have already had that information and that they would know it. But the real question as to whether it should be made public now is a really difficult question.
Interesting.
Kim, Mike, any questions?
No, negative. I already flapped mine enough.
How long does a state appointed defense attorney stay on as the attorney for someone who's already accepted a plea deal and case is closed?
Yeah, generally it should terminate whenever, even though he waived his right to appeal, whatever the appeal period in Idaho is, whether it's 14 or 30 days, it should, really, for the most part, terminate after that, unless you can make a good cause showing as to why you need to be doing either something with the records or communicating, with your potential witnesses, shutting everything down. So it should be a relatively short period after the plea, because I'm not understanding what legal advice you would be needing after that time that should, come from an indigent provider.
Right. So, excuse me, I'm sorry. If something were to happen on his side of things, Kevin, because we're gonna have to bring this to a close. I would really love to do another one though, if you ever have time, because there's so much more I didn't get to ask, and a lot of people wanted to ask. By the way, everybody very much loves you being here and is very, very, very appreciative of you being able to do this. So,
well, thank you. I can tell my wife that there's somebody who's deeply appreciative of my time.
Oh, Kevin, once again, you stop
go.
it.
There you go. Do you?
Well, yeah, I know that. Go ahead.
No. Go ahead with what you're going to say. I didn't mean to cut you off there.
Well, I was going to say that, there are, just from reading comments and as I was following the case and doing things with the news, and I know there's a lot of people who have a lot of questions about the fact pattern from, the night of
course,
crime and investigations that they believe that, are not answered, or that the plea itself, that, either Mr. Kohberger isn't involved in any way, or that there's a lot more to it. So I know there's a lot of interest and a lot of issues relating particularly to that we probably didn't get into today.
Of course, of course. So at this point, do you, if anything were to happen, again, from your point of view, if it was you, what would you expect to see if there was any kind of an appeal or anything at this point, or what could you expect to see, I guess, for lack of better terms? So sorry.
I think the most likely thing that you would see after the plea is Kohberger filing a personal restraint petition, which is a collateral attack on his judgment and sentence, and arguing that he should be entitled to a new trial, that his plea should be withdrawn, he should be entitled to enter a new not guilty plea and go to trial, and it would be based on either ineffective assistance of counsel and or newly discovered evidence that wasn't available at the time.
Of course.
That he made the decision to enter his plea. If a third party came in and confessed and said, I did it all.
Right. Yeah.
But those are the two primary areas: newly discovered evidence of whatever sort, confessions or discovery that wasn't provided, or new witness testimony, and or ineffective assistance of counsel.
And
that would be my guess. Now,
yeah, of course. Do you see this happen often, Kevin, in a case? Well, this is like a 1 in a million case, of course, but do you see that happen often? Is this something that you see go down on a regular basis, or is it rare, I guess you could say?
It is not uncommon for it to happen in felony cases, but I will say, I mean, I've never had it happen in a death penalty case or in a homicide case where somebody has pled guilty and then come back and attempted to withdraw it on any of those bases.
Gotcha. Gotcha.
Because generally, particularly on a death penalty case, you file a lot of motions that you normally don't file even on a homicide case. And you know, as I said, there's more of a defined checklist as to the things you have to do. And so, you know, if you look at the pleadings, pretty thorough discussion and attempt to suppress a lot of the most damaging evidence. So it's a very tough barrier to meet legally. And then secondly, the question is, you know, why would you have admitted it and entered a plea of guilty if you weren't involved at all?
Yes, of course.
So.
Absolutely. Absolutely. Well, again, I typically, any last questions, guys, because we're kind of over. And again, before we do that, before I set you free, I should say, would you be willing to come back again and do this again with us, or specifically maybe even with each one of us, you know, by ourselves alone? Would you be interested in doing any of that?
I'm open if there's interest. You know, you may get a flood of people saying, no, please spare me. But no, I'd be happy to talk with you later. As I've indicated, my March has gotten filled up kind of unexpectedly.
Sure. Sure.
And but if we can find a mutual time, yeah, I'm happy to discuss it. I think it's interesting, and I think everybody who have legitimate questions.
Yes.
That you know, if we can provide some answers or make more sense than it has so far from a legal standpoint, that's part of what I'm doing. Just not trying to give you my opinion as to what really happened, but trying to explain the process.
Education. Yes.
Yeah.
And exactly. And I'll tell you right now, you're number one in here today. Everybody in here is very grateful. They love you. They appreciate you. So,
I mean, this isn't typical attorney talk, Kevin. You know?
Yeah. This is good.
Everybody has that thought in their head of attorney money, you know, not level headed. Just we don't want to talk to attorneys unless we're in trouble.
Yes. And it's very much appreciated. It is.
Just being honest.
I think you're stuck with us now. Then if you're agreeing to it, then we will be coming back for you, sir. 100%. So thank you.
Not if that guy who just talked is back on it now.
You stop it.
He's the resident comedian. We got to keep him around to make him laugh. Yes.
Alrighty. Well, thank you, and it was enjoyable talking with you and meeting all of you.
Thank you, Kevin.
You as well. Thank you so much, sir. We appreciate
you
very much.
Much appreciated.
Yeah,
Very
I hope.
All right.
Please have a wonderful rest of your night, and we will reach out to you again at some point and do this again. Thank you so much.
All right. Thank you. Goodbye.
You have a wonderful night, sir.
Good night.
Take care, Kevin.
Good night.
All right.
Wow.
That was great.
Wonderful.
Very
Yes.
informative.
Yeah, and we will be doing that again. I know I was trying to grab the questions that I could grab, guys. I was starring them. There were so many of them. I'm so sorry that I didn't get to some of you. I tried to group them together. My apologies to any that I didn't. I did not do it on purpose. I can promise you that. So
That's a lot. You did well.
yeah, there were so many. There were so many. I was
Yeah.
just like
There's a lot.
all over here, but and it was amazing what we did.
Very
get out of it.
level-headed. He's yeah.
I
Mhm.
really enjoyed that a lot. I think we learned a lot. I'm grateful for him, and we will definitely be going back to him. And I think if we
I feel
can
like
get
he has a
him-
lot of opinions that are hiding that would be very interesting.
yeah, and that's the thing is I understand too. He's got to be careful because he's an attorney,
Yeah.
blah blah blah, so on and so forth,
Mhm.
which makes
Yeah.
sense, you know. And I'm gonna see if he'll if we can get him maybe like with each of our channels alone as well,
Yeah.
you know, and do one-on-ones with him like
Mhm.
that. I think that would be helpful too in the category that way with each separate chat. That would help too. So great stuff, guys. And you guys, your questions were amazing. Just so you guys know out there, all of you and every channel in here, all the turtles and the peeps, you guys were asking amazing questions as well as, of course, the meatballs. We love you guys so very much. Peep, peep, peep.
Did you name that thing yet?
Yes, this is Gerald, and you don't question Gerald.
Oh gosh,
You don't
damn it!
question Gerald. That's right.
Holy shit! Well, I hope he doesn't shit on your keyboard.
No. Yeah, one of the moderators, can you please put my email in the chat for Fran
Oh,
find
yeah.
out, please? I appreciate that.
If you ever had to
And,
clean up duck shit, you know.
whack, whack.
Did we have?
Um,
They lay eggs in pools.
Wait till you see what I have to show you Monday.
Uh-oh.
Nope, I'm going blind tomorrow. Nope, crime o'clock is over. I'm checking out, Kimmy.
Checking out.
You're done.
Walking out. Right.
Unsubscribing. I didn't do it. It was YouTube.
So
Sorry.
before we get out of here, guys, please make sure to hit the like button on all these channels. Please share this out. Last but not of all, before we get out of here, Miss Logan, do you have any last thoughts on this before we take off?
No, I think it would be great to have him come back or even maybe do a couple one-on-ones just so we
Yeah.
can maybe get more questions in there. But just an excellent guest. And I thank everybody for showing up and paying attention and throwing your questions in the chat. I apologize we couldn't get to all of them, but we appreciate them. And we promise we'll have him back so we can get more questions answered. But thanks everybody for showing up.
Yes. Yes, absolutely. Amazing. And Miss Kim, how about you, ma'am?
Yes, big shout out to Kevin. Thank you, Kevin, for your time tonight. It was so informative, and I know the chat appreciated you. We all appreciated you. So thank you again. Thank you, Mike and Dago, for making this happen for us. It was great. It was
Absolutely. I
way
mean, this
better than I thought. So
Well,
yeah, awesome.
this was thank you, Kim. Absolutely correct. This was all Mr. Mike here. He's the one that put this together.
No, buddy. You, I just asked you the other night if you wanted me to babysit it.
You did amazing with it. You got him. What was it? 2 days, guys.
Yeah.
2 days.
Yeah.
No, Kevin was
And-
super responsive though. Great guy.
Absolutely.
You know?
Yes.
Yeah.
Yes,
and,
Temple.
and we can all thank Andrew Myers for providing the information to
Oh,
reach
yeah.
out to Kevin. Again, Andrew is a very good friend
Yeah.
of the channel.
Mhm.
And he loves the channel here as well, and all of these channels actually. And so thank you again, Andrew. If you can hear this, we appreciate you to no end, my friend.
You know
And
what I
again-
think would be real interesting is you, him, and Andrew.
I was actually thinking about doing that
Yeah.
too. Yeah, that would be a great conversation, I
Mhm.
think. For
That'd be
sure. Any
fun.
last thoughts, Mike, as we get out of here?
No, just appreciate everybody coming out. That's about it.
All right, buddy. Well, we appreciate you and thank you for what you did to make this happen in 2
Yeah.
days, guys. It was amazing.
So good.
And as far as I'm concerned, guys, you guys are amazing. I appreciate all of you so very much. Thank you to these amazing moderators. within the typically unique community, the Bronx Tales true crime community, the Last 24 community, and all of you in general are just amazing. I don't care where you're at, what you're doing, who you are amazing. And you're all the beautiful people, as I always say. So thank you guys. Thank you to the moderators. Thank you to Mike. Thank you to everybody. You guys are amazing. It was a great show. I'm super excited and happy about this so very much. And please make sure you guys hit the like button. It just takes a minute to pop over to each channel, hit the like button and share it out. Please and thank you. If you're not subscribed, please make sure you do. Double check that and make sure you hit the notification bell as well. I will be moving on. I believe Logan is as well, to the Crimes After Dark over at Devil's Advocates, 9 p.m. Eastern Standard Time. Please hop on over there for some more entertainment, I guess you could say. Great conversation, great people, great talk. So, guys, don't forget to love yourselves and love each other. And don't change nothing. You guys are the beautiful peeps. Have a great night, everybody.
See you. Bye.
everybody. Bye.
Thanks.
Bye.
Thanks for coming through to the verdict room where we're seeking truth. Yeah, we're seeking truth. Hey. Last 24, they rewind it. True crime heads go find it. Breaking every angle, every track. Bronx telling tales, keeps us on track. Typically unique, never act. Being real, being sharp, being exact. Exposing every secret in the dark. Every little timeline, every mark. Welcome to the verdict room, where we're seeking the truth. Looking for answers, bringing the facts to you. They break it all down. That day goes cafe seats, working together, throwing revelations at your feet. Oh.
Crime scene chart, they erase that. Put the story back, then replace facts. Looking for the motive in the cracks. Red yarn on the board, then it snaps. Voices in my ear through the week till they hit play. Then we speak. Files on the table, case on the line. They don't just tell it, they define.
Welcome to the verdict room, where we're seeking the truth. Looking for answers, bringing the facts to you. They break it all down. That day goes cafe seats, working together, throwing revelations at your feet. From the Bronx to the world, let it ring. Every missing little detail that they bring. Dropping that gavel when they're done with the beat. Thanks for tapping in. See you next week. Welcome to the verdict room, where we're seeking the truth. Looking for